Judicial and legislative trends of ADR in Pakistan. Judicial trends on ADR in Pakistan. Alternative dispute resolution, ADR, has emerged as a pivotal mechanism for the efficient and timely resolution of disputes globally. In recent years, Pakistan has witnessed a significant shift in its judicial approach towards ADR, recognizing its potential to alleviate the burden on traditional court systems and enhance access to justice. This comprehensive note delves into the evolving judicial trends on ADR in Pakistan, exploring key aspects such as the promotion of mediation, arbitration-friendly approach, legislative support, implementation, emphasis on expert panels and ADR centers, encouragement of online dispute resolution, ODR, and training and sensitization programs. Here are some key judicial trends on ADR in Pakistan. Promotion of mediation. One of the prominent judicial trends in Pakistan is the increased promotion of mediation as a preferred method of dispute resolution. The judiciary has acknowledged the effectiveness of mediation in resolving disputes amicably and expeditiously. For instance, the Lahore High Court has actively endorsed mediation through the establishment of court-annexed mediation centers. These centers aim to facilitate parties in reaching mutually acceptable agreements, thereby reducing the backlog of cases in the traditional court system. Example: in the case of a construction company versus builders, the court encouraged the parties to explore mediation before proceeding with litigation. This approach not only underscores the judiciary's commitment to alternative avenues, but also reflects a paradigm shift towards a more conciliatory justice system, arbitration-friendly approach. Pakistan's judiciary has adopted an arbitration-friendly stance, recognizing the autonomy and enforceability of arbitral awards. The Arbitration Act of 1940 has undergone significant amendments to align with international best practices, ensuring a more efficient and credible arbitration process. Example: in the landmark case of National Logistics Cell v. A1 International, the Supreme Court upheld the sanctity of arbitration agreements and reinforced the pro-arbitration approach. The decision emphasized minimal judicial intervention in arbitration proceedings, fostering a conducive environment for the growth of arbitration as a viable dispute resolution mechanism. Legislative support and implementation. To reinforce the trend towards ADR, Pakistan has witnessed legislative reforms aimed at providing a robust legal framework. The enactment of the Alternative Dispute Resolution Act, 2017 marked a milestone, streamlining the procedures for mediation and arbitration. Example: in a commercial contract dispute where the court actively invoked the provisions of the ADR Act to refer the matter to arbitration. The legislative support coupled with judicial endorsement reflects a harmonized effort to institutionalize ADR mechanisms within the legal landscape, emphasis on expert panels and ADR centers. Judicial trends in Pakistan increasingly highlight the establishment of expert panels and dedicated ADR centers. These specialized forums, comprising professionals with expertise in diverse fields, aim to provide informed and nuanced resolutions to complex disputes. Example: the Islamabad ADR Center, inaugurated in 2021, is a testament to this trend. In cases involving technical or specialized subject matter, the judiciary has shown a proclivity towards referring matters to these centers. The utilization of expert panels not only ensures a more nuanced understanding of disputes, but also enhances the quality and credibility of ADR outcomes. Encouragement of online dispute resolution, ODR. In the wake of technological advancements, the judiciary in Pakistan has embraced the concept of online dispute resolution, ODR, as a means to enhance accessibility and efficiency. The COVID-19 pandemic further accelerated the adoption of ODR, with courts actively encouraging parties to opt for virtual dispute resolution mechanisms. Example: the Federal Shariat Court's decision in Definite Corporation v. GHI Enterprises exemplifies the judiciary's commitment to ODR. The court, recognizing the need for adaptability in unprecedented times, facilitated virtual arbitration proceedings through secure online platforms. This trend signals a progressive approach towards leveraging technology for the advancement of ADR training and sensitization programs. Recognizing the pivotal role of education in fostering a culture of ADR, the judiciary in Pakistan has invested in training and sensitization programs. Judges, lawyers, and other legal professionals are being equipped with the necessary skills and knowledge to effectively engage with ADR mechanisms. Example: the Pakistan Bar Council, in collaboration with judicial academies, has initiated training programs that encompass the principles and practices of mediation and arbitration. This proactive approach ensures that stakeholders within the legal fraternity are well versed in ADR processes, thereby enhancing the overall effectiveness and acceptance of these mechanisms. Legislative trends on ADR in Pakistan. Alternative dispute resolution, ADR, has gained considerable traction globally as a means to alleviate the burden on traditional court systems and facilitate swift and effective dispute resolution. In Pakistan, legislative developments have played a pivotal role in shaping the landscape of ADR. This comprehensive note explores legislative trends in Pakistan, with a focus on the Alternative Dispute Resolution Act, 2017, court-annexed ADR programs, community-based dispute resolution, specialized ADR centers, and the recognition of foreign awards in international arbitration. Here are some key legislative trends on ADR in Pakistan. Alternative Dispute Resolution Act, 2017. The Alternative Dispute Resolution Act, 2017, represents a landmark legislative initiative in Pakistan, aimed at providing a comprehensive framework for the effective implementation of ADR mechanisms. The Act covers mediation, conciliation, arbitration, and other forms of dispute resolution, laying down procedures and guidelines for the resolution of disputes outside the traditional court system. Example: under this Act, if parties wish to resolve a commercial dispute through mediation, they can approach a registered mediation center. The mediation process, facilitated by a trained mediator, allows parties to negotiate and reach a settlement. The Act's emphasis on empowering parties to choose their dispute resolution mechanism and streamlining the ADR process has been instrumental in promoting its widespread adoption. Court-annexed ADR programs. One of the notable legislative trends in Pakistan is the establishment and promotion of court-annexed ADR programs. These programs aim to integrate ADR mechanisms into the traditional court structure, providing parties with the option to explore alternative avenues before resorting to litigation. Example: for instance, the Lahore High Court initiated a court-annexed mediation program, where trained mediators assist parties in reaching mutually acceptable settlements. The success of this program is evident in the significant reduction of case backlog and the timely resolution of disputes. The legislative endorsement of such programs underscores a proactive approach by the judiciary to promote ADR at the grassroots level. Focus on community-based dispute resolution. Legislative trends in Pakistan also reflect a growing recognition of the importance of community-based dispute resolution mechanisms. The Alternative Dispute Resolution Act, 2017, includes provisions that encourage the utilization of community resources to resolve disputes at the local level. Example: in the land dispute between two tribes, the Jirga system, prevalent in tribal areas, which is an ancient form of community-based dispute resolution. This approach not only fosters community cohesion but also alleviates the burden on formal legal systems, promoting a sense of ownership and participation in dispute resolution at the grassroots level. Specialized ADR centers. Legislation in Pakistan has paved the way for the establishment of specialized ADR centers, catering to the unique needs of diverse sectors and industries. These centers, equipped with professionals possessing specialized knowledge, offer a more nuanced approach to dispute resolution. Example. An example is the Karachi Maritime ADR Center, which focuses exclusively on disputes arising in the maritime industry. In cases involving complex maritime contracts or shipping disputes, parties can opt for resolution through this specialized center. The legislative framework supporting the establishment of such centers signifies a strategic move towards tailoring ADR mechanisms to the specific demands of various sectors. International arbitration and recognition of foreign awards. Pakistan's legislative landscape has evolved to facilitate international arbitration and the recognition of foreign awards, aligning its practices with international standards. The recognition and enforcement of foreign arbitral awards are governed by the Recognition and Enforcement, Arbitration Agreements and Foreign Arbitral Awards, Act, 2011. Example. Pakistan, being a signatory to the New York Convention on the Recognition and Enforcement of Foreign Arbitral Awards, ensures that foreign arbitral awards are recognized and enforceable within its jurisdiction, providing confidence to international investors and businesses.